And joining me now to speak about this is Legal Practitioner Inibehe Effiong. Good to have you join us. He joins us in the studio. Good to have you join us.
Thank you for having me.
So this issue has been on, the issue around open grazing and a ban of open grazing in the country. But now we're here, the herdsmen under the auspices of the Miyetti Allah Qatauri, are now planning to take this case to court. And it does seem that they have the backing of the Attorney General and the federal government. What do you make of this?
It is a welcome development that the herdsmen, in quote, maybe have now come to the realization that when people are aggrieved with actions of government, the proper thing to do is to go to court to seek redress, to ventilate their grievances, and not to resort to self-help by taking laws into their hands, killing people, destroying people's crops, and challenging institutions of states in a manner that is not recognized by law. So they have the right to go to court. But what worries me is that when you have the Attorney General of the Federation, not the Attorney General of herdsmen, not the Attorney General of Northern Nigeria, not the Attorney General of Miyetti Allah, coming out publicly to say that what the herdsmen are saying is correct, that they have the right to freedom of movement. Of course they have the right to freedom of movement. However, the Attorney General ought to know that under Section 41 of the Constitution, the right to freedom of movement is only guaranteed to citizens of Nigeria. That section specifically says every citizen of Nigeria. So the question is, in the population of Nigeria, can we categorize cattle as citizens for the purpose of fundamental right to freedom of movement? Because cattle don't have the right to freedom of movement. In any event, nobody is saying that people should not rear cattle. The argument is that what civilization requires, what necessity requires, what morality requires, in fact, expediency, is that the era of going about with cattle moving from one part of the country is outdated. But we must also make the point that states have validly enacted laws, states in the south and Benue, of course, against open grazing. Until those laws, except those laws are invalidated, those laws are existing laws, the police have a constitutional obligation to enforce those laws. So therefore, the proper thing to do is for them to go through the court as they are claiming. But let us not forget that this is just hypocrisy, because before now, the herdsmen have publicly challenged the powers of governors to enact these laws. They have even vowed to disobey these laws, to flout these laws that we have seen in Benue. And what has been the reaction? Festival of blood. People are being killed. People are being slaughtered. The government is standing by and watching these things unfold.
And you spoke to an issue which is enforcement, that the state police commands do not have a choice but to enforce these laws. We know that they also have to get directive from the force headquarters. If this becomes a subject of litigation, how difficult will it be to enforce these laws within the states?
No, they don't have to seek the approval of the force headquarters. Section 215 of the Constitution is clear that the governor of a state may give to the commissioner of police in that state such lawful directive. However, the CP has the discretion to seek clearance from the force headquarters. But when you have an existing law validly made by the House of Assembly, and the police is supposed to be the primary law enforcement agency, the question of clearance does not arise. Because that, if, for example, the IGP said don't enforce, are we saying that the IGP can sit in his office and validate laws validly made by the Houses of Assembly? The answer is no. So the police
at this point, I am asking at the point where it becomes a subject of litigation. If it becomes a case in court where the headers have said they are going to go to court. Now, once it becomes a subject of litigation, do you put, because we've seen the case of the VAT in Rivers State, where at one point the court said River State go ahead, and at another point the appellate court they did go with the FRS, and that law has to be put on hold. Does it have to be put on hold? Or can enforcement continue?
Absolutely not. It has to continue. The doctrine of lis pendens, of course, which of course usually apply to property cases. For example, if a property is under litigation, you are not expected to go and acquire it. But when you have an existing law validly made by the House of Assembly in the exercise of its powers under Section 4, the fact that someone has gone to court to challenge that law does not affect enforcement. In the case of that is why the Court of Appeal had to make an order restraining the states from going ahead to implement those laws until the appeal is determined. There is no injunction from any court of law that has prevented any state or the police from enforcing the anti-open grazing law. To that extent, what the Attorney General of the Federation must do is to insist that the police must enforce the anti-open grazing law. That is the position of the law. It's as simple as that.
And it's interesting you spoke to the center point of this case, which is the freedom of movement. We'll see how this plays out. Thank you so much for always for your analysis, as always. Inibehe Effiong.
Thank you.